I want to start off with the earliest point in a company's life, which is IP. So I've received some questions from the audience already, and I'm going to share with them with us. Marty, so what legal structure is best for my company? That was one of the first questions asked.
What legal structure?
What legal structure?
The main ones we typically see would be a Delaware C Corp or a C Corp or an LLC. Those are the two obvious choices. As between those, it really depends on what type of exit you're expecting. If you kind of visualize success, how would you exit? How would you make money in the company? And it's all about taxes on that exit. So the difference between a C Corp and LLC, to just oversimplify it, an LLC doesn't pay taxes and a C Corp pays taxes. So when you exit, if you were to sell assets, or if you were to take your money as a license, or receive anything like royalties, milestone payments, anything like that, if you receive those in a C Corp, you're going to pay taxes at the corp level, which are, depending on state and federal, could be very substantial, could be 45%, 40%. Then when you take those proceeds and try to distribute it out to the owners, you'll pay another tax, a double tax. There's some offset, but it's a double tax as a dividend tax. So anything you do in a C Corp where you're selling assets or monetizing or licenses or other properties and royalties and other payments is going to be double taxed. So a C Corp is very tax inefficient. However, if you think you're going to exit by selling the company, by selling the shares to a buyer, which is the typical way most of the startups exit, the C Corp is far superior for a couple of reasons. One is you pay capital gains only on the sale of those shares, so it's capital gains tax on the sale of the shares, and most of the startups can be set up as what's called a qualified small business stock eligible company, which means, to oversimplify it again, if when you're setting it up, the company is worth less than $50 million and otherwise makes some other easy to comply with standards, you're going to be a qualified small business stock. If you receive qualified small business stock when you first start the company and buy your shares and hold those shares for 5 years, which is not a long period of time when you're thinking about one of these startups, and then sell the shares, every shareholder in the company enjoys a $10 million tax holiday federally. You still pay state tax, but your first $10 million in taxes federally is not taxed. That is a self-reporting tax as well, and so people, not going to give tax advice today, but people do a lot to design around so that they can split their shares up into separate shareholders and expand that tax as well, and there are strategies people use for that. So if I'm holding, as a founder, 5 million shares, and I decide through some estate planning and tax planning to spread those shares around with a foundation and family members and so forth, every one of those shareholders can be eligible for that $10 million tax holiday. So you can see how that could be very, very lucrative, far more lucrative than the benefits you would get from an LLC. And so when we ask people to make a decision at the beginning, it's hard to know what's going to happen, but most of the time people will opt for the C Corp because of that qualified small business stock advantage. But again, you have to visualize your exit. If you're going to run the company and do licenses, you'll want to have an LLC. If you're going to run the company, grow the share value, and sell the shares, you'll want to have a C Corp.
What about fundraising and investment agreements? What should I know about them as a startup?
So, at the early stages, most of the startups will get funded through, if they're not getting a grant or some other funding, they'll get funded through one of two ways at the C stage. Usually it's either a convertible debt or it's a SAFE. SAFE is a simple agreement for future equity. The differences are a convertible debt, like any loan, has an interest rate, it has a maturity period, so it has to be paid back at some time, and usually, not often, but most of the time, the investors in that will require some sort of security. So it's a secured note that gets paid off in the future and carries an interest rate between when you take the note down and when you pay it off. The SAFE is a device that was invented, up in Silicon Valley by the tech practice to move very, very quickly in terms of seeding companies. There, it's a little different when they have something that's a hot thing. Everybody's rushing to get into it. We have a little bit more difficult time in our practice selling in life sciences, getting people involved at the early stages because the risk is so high and the timelines are so long, and there's also regulatory risk and other things. So, the main advantage of a SAFE for a founder is there is no maturity date. So you take the money and you're not under pressure to raise the next financing before that maturity comes up. You don't have to secure it with your assets, and there's no interest rates. So far better if you can convince investors to do a SAFE. The pressure that you're under with a convertible note is, and both this, I should say, both the SAFE and the convertible note are essentially early closings of your first financing, in the sense that they both convert into the next financing. They convert into a future financing, typically at a discount, and the discount ranges from sort of 20 to 40%. The disadvantage of the note is, because of that maturity date, you're under some pressure to get that financing done before that maturity date comes due. You're also paying interest, which, if we were talking about this 2 years ago, we'd say the interest is negligible, but interest rates are real now, so you're paying interest, and that's going to result in additional dilution when it actually converts.
So how does you align with the Y Combinator SAFE?
So the SAFE is, as I said, is something that's sort of an invention up in Silicon Valley, and it was invented by an angel group called Y Combinator. And Y Combinator came up with a couple of different versions of this SAFE, working with a couple of firms, including ours, to make it work from a securities point of view, and also make it work under applicable laws that apply to lending and usury and things like that. And so most of the time, to the extent that people are willing to do SAFEs, the default is to use the Y Combinator SAFE, and there's a couple of different forms of it, but they're all basically track convertible notes. They're a contract that basically says you're investing in this company money, you're getting this contractual right to have your SAFE converted into a future financing at an agreed upon discount and with some agreed upon terms. And usually some of the forms contain what's called a most favored nations provision, and some of them don't. That's really the main thing that people argue over. And the most favored nations provision basically says, if the company goes and does another SAFE after you've taken my money, I get the benefit of any better terms that you give a future investor. So those are the kinds of things that get negotiated. The discount gets negotiated. Like I said, it ranges in today's market between like sort of 20% and 40%. And there may be some other negotiation around additional rights that you may get, even though you don't own the equity. Through the SAFE contract, you can get certain information rights to get financials or updates about the company and things like that. All that's in the realm of one or two or three of the different forms that Y Combinator has on their website. You can go check them out. They're available to everybody.
But Marty, what happens in later stages? So all this is true for early stage companies. What happens in later stages?
So the later stage companies in today's practice, so you've done a SAFE, you've raised, let's say, $2-3 million, and now you've been able to get some data or make some progress that makes you attractive now to a venture finance group or venture fund. Most of the time now, in those early stages, everyone defaults to what's called the National Venture Capital Association forms. And again, you can go and you can look at those, and there's actually some pretty good information. There's information on our website, there's information on the NVCA's website that can take you through and explain what those are. But it's basically a series of documents that allows a company to issue preferred stock to investors. And the reason you use preferred stock is you want to keep a differential between, the tax laws allow you to keep a differential between the value of your common stock and the value of your preferred stock. So when you start the company and issue founder stock, you're issuing stock at probably 0.001. It's a de minimis value. You're paying for those shares. So you've established that you bought the shares at the fair market value, and you started your qualified small business stockholding period and your capital gains stockholding period. Now you fast forward and you're going to raise money at, let's say, a $5 or $10 million pre-money valuation, and you're going to raise $5 million. Well, the post-money valuation will be $10 million pre plus $5 million, $15 million post. So you've taken the value of the company up. You can no longer issue common stock to advisors, new employees, new partners, consultants, whatever, at that de minimis value, because that would be a discount that would be taxable to those people upon receipt of those shares, and they wouldn't be able to sell the shares to pay the tax, which would be unfortunate. So you have to go get what's called a 409A valuation, and that lets you recognize that the preferred that you sold may be worth $15 million, but the common that you're selling may have a much lower valuation because the preferred has rights, preferences, and privileges that have been negotiated by the investor. Things like liquidation preferences, things like special voting rights, board seats, shareholder rights to prevent you from selling your shares to anybody but them, a whole bunch of things. That's what is in those NVCA documents. They consist of a model share purchase agreement for preferred stock. They consist of a model amendment to the articles of incorporation to create the preferred and set forth the terms of the preferred, a voting agreement, and a shareholders agreement. And that set of documents is the core that people use for venture-backed financings.
So I want to touch base upon other, while I have you here, other areas of the law when it comes to, startups. One that, is more intuitive is the intellectual property aspect of it. So with regards to protections, right, the patents are inobvious, but what intellectual property protection should one consider that are above and beyond just the provisional?
Yeah. So the first thing we typically do with a startup when we bring them in is we want to again, like, visualize success, right? We all want to be successful. Visualize success. What does that look like from an intellectual property strategy? What would the area that you would want to have your flags planted on and own be? And then once we determine that, we can work backwards and come up with a strategy, and then we can work backwards from there and come up with a strategy that a startup can afford, right? So one of the things we do with startups in the beginning is we try to think strategically about how to use provisional patents. Provisional patents can be written. They can be broad. They can be narrow. They can be written and filed, and then you have, depending on what your strategy is, between 12 and 18 months to perfect them. So you can keep going back and adding to them and tightening them up and changing the language and zeroing in on exactly what you want. And they're very cheap to file, and most of the time, with a little guidance from us, the founder or the inventor can draft them, a pretty good job, and that's something that can be filed and then perfected over time very inexpensively. I think the filing cost is $250 and a couple hours of some guidance, and you're off to the races.
But beyond that, let's say we're talking about algorithms, software.
Okay, so software's a special animal. So software, and we have increasingly, especially with AI, things like that, we're increasingly having devices and ophthalmology technologies that work with a software algorithm. The trick with software is, if you want to patent your software, you're going to have to put the algorithm inside the patent, and that's ultimately going to be disclosed publicly. And you have to ask yourself how easy or how difficult it's going to be for someone to reverse engineer my software if I've shown them the path with the algorithm, and they can make some adjustments and then create their own and maybe patent their own or use know-how. So we typically see our clients increasingly with software, and frankly with manufacturing processes and lots of other things. We're increasingly seeing people use know-how strategies. So know-how is not a filed patent. It's the secret formula. It's the company's trade secrets that are kept highly confidential and owned by the company and never exposed through the patent filing process to the world, and can only be seen in connection with partnerships and things like that where you've negotiated a non-disclosure agreement or a confidentiality agreement. And so I would typically advise my clients to use a know-how strategy for software and try to patent the things that the devices that the software works with.
With regards to navigation employment, I'm moving on to employment laws, which is another aspect of starting a startup. And so how should I navigate the employment laws with regards to hiring new talent?
Yeah, so when we're working with the startups early on, the things that we first confront is they don't have a lot of money, so they're trying to stretch that money, and they want to use consultants. And depending on the state, California is being a particularly bad one. I think France is the only place that's worse to employ people. Depending on the state, you've got some challenges, right? So if you have somebody that's working for you full time, you have to make sure that they're characterized properly as between employee and consultant, because the tax man in the state of California and federally wants their social charges, and they don't want you getting out of those by hiring somebody who's working full time and just putting a label on them that says they're a consultant, and therefore you don't have to have withholding taxes. It's up to them to pay their own taxes. That's not going to fly. So you have to be very careful about characterizing people the right way as between consultant and employee. And you also have to be mindful of the fact that a lot of the people that you want to work with, because they're experts in this area, may have worked for a bigger company, particularly when you get to the point where you're hiring people that are involved in sales, and they may be subject to non-competes. And while non-competes are not enforceable for employees in California, they can be enforceable for people you're hiring that worked in a different state when they signed the non-compete, and their non-compete is covered by the law of that state. And so you don't want to start your company, hire somebody, and immediately have a snoot full of lawsuit from a big company that doesn't like the fact that you're going to compete with them 5 years from now.
And last question that we've gotten, and then I'm going to open the floor for questions and answers from the audience. What type of regulatory issues I should be thinking about in early stage companies?
Yeah, so the things we try to get the companies to think about early on is, in order to track financing, you're going to have to really understand well your regulatory pathway and your reimbursement pathway. If you don't understand your regulatory and reimbursement pathway, you won't know the right amount of money to raise and what the milestones are and the value enhancing milestones that you're asking someone to fund. So when we go out to fund an early stage company, you're asking someone to take some execution risk because the technology may not be formed, but you're also asking them to take a lot of risk in terms of whether or not you'll ever get regulatory approval, and even if you get regulatory approval, whether or not you'll get reimbursement. And there could be gaps even between when you get regulatory approval and when you get reimbursement, and you'd have to have money to have continued access and things like that. So really at the very beginning, you're probably far away from filing regulatory approvals, but it's essential to understand which pathway you're on. If you're on a 510K, that's one amount of money that you need to raise. If you're on a PMA, that's a total another ball game altogether. And so really understanding that, testing it with your advisors, and understanding the timing and the type of regulatory pathway and the timing and the type of reimbursement.
Well, thank you, Marty. I would like to open the floor for questions. I think there's people on the floor with mics, so just raise your hands if there's any questions for Marty.
Stun them to silence.
Yes.
Again.
Maybe we hit them with a 5-ton hammer.
It's free now.
Doing legal first thing in the morning.
Bob left.
I'll give you your question. What's your opinion on safes in qualified small business stock, and whether the time you bought the safe qualifies for starting the clock?
That's a really good question. So one of the things that we'll debate is whether a safe or a convertible note is better for starting the qualified small business stock clock. For sure, a safe will start the clock because it's considered equity. There's no question it's equity. So I think everybody in the tax bar agrees that the safe will start the clock. There needs to be some language in there to help it, but we think with the right language, a convertible note can also start the clock, because the convertible note is not really debt when you're giving a loan to a company that's probably not going to be able to repay you on that maturity date unless a bunch of other stuff happens. It's probably more like equity than it is debt. But what we do in the convertible note context is we'll add language to the note, and we'll put certain language like this in the SAFE as well that basically says, this note is meant to be equity for tax purposes. So those magic words, I'm told by my tax guys, is enough to perfect the argument. Now remember, qualified small business stock is self-reporting, right? There's no form that you file. So if you work with your advisor and you take reasonable positions, most people will believe that the qualified small business stock should hold up when it comes time to report the transaction, the exit transaction. It's a good question.
Just to touch on that again, what do you need for the audit when you get it?
Yeah, I mean,
Did you hear that?
Yeah, he was asking, what do you need for an audit for a qualified small business stock? Well, that's my point, right? So it's self-reporting. So just like any other positions you take in taxes that aren't, filling out a form, you need to have your, you want to, as a taxpayer, say, I took advice from professionals, I documented things carefully. You'll certainly want to have, in the purchase agreement, when you purchase the stock, you want to have some language in there that contemplates that you're purchasing qualified small business stock, that it meets the requirements on qualified small business stock on the day you buy it. You have to meet the requirements on the day you buy it. If you bought something that meets it because it's under 50 million on the day you bought it, and a year later it's more than 50 million, you still qualify. It's when you buy it that you have to meet the requirements. And then, like anything to prepare for an audit, you want good documentation and have advice from professionals that you can point to and put them under the bus if there's a problem.
Just want to extend this question. In our group, at a local angel group called New Fund, there's a concern that the SAFE may not be qualifying for the QSBS. Was this litigated in the past by IRS?
I don't think there's any litigation that I'm aware of, and I don't think the IRS has taken a position. But I think there's language that you can put in both the SAFE and the convertible debt that can help your case. But I don't think you can be certain that it'll be the case. But what ends up happening in any event is most of the time, by the time the SAFE or the note converts, the company still qualifies for qualified small business stock. So really what you're talking about is how long of the holding period, right? Because if you qualified for small business stock when you took the SAFE, and 8 months later the company converts into a Series A financing, and the Series A financing is $15 million post, in my example before, they still qualify for qualified small business stock, so you would get it as of that date. You might lose some holding period. Similarly, if you decide, in the first question, LLC versus C Corp, if you decide to start as a C Corp because you have some tax benefits to doing so, but in anticipation of taking venture finance, you convert to start with an LLC, pardon me. If you start with an LLC in anticipation, convert to a C Corp, you can still qualify for qualified small business stock at that time. It's just that your holding period starts on the day of conversion to C Corp, not on the day you form the LLC.
So with that said, thank you so much, Marty.
My pleasure.
It's been a pleasure to learn this first thing in the morning. Very in-depth questions. Are you going to stick around for?
Yeah, I'll be around a bit.
Okay, so you can answer questions
Yep.
off topic. Okay, perfect. Thank you so much.
Thank you.